Well, good morning. Thank you, Madam Clerk. Welcome to the May session of the Court of Criminal Appeals. Let me introduce my colleagues. To my left, your right, Judge Kyle Hickson from Knoxville. And to my right, Judge Tom Greenholz from Chattanooga. I'm Ross Dyer from Memphis. Couple of quick things, 20 minutes aside. Obviously, if the appellant wants to reserve any time for rebuttal, please let us know at the beginning. The clerk will keep the clock for us in your pretty lights. We have read the record, we've read the briefs, so use your time as you want to as far as facts are concerned and letting us know what's in the record. With that, any preliminary matters?
No, Your Honor.
We want to do the introduction? Did you want to do the introduction? I'm sorry.
I think A.G. Ben Ball wanted to say something.
Okay. Mr. Ball?
Please the court, good morning. I just wanted to introduce to the court one of our new attorneys. This is Christian Clace. This is his first argument. He came to us from Northwestern Law School, and welcome him.
Well, welcome. I'm sure you'll do a great job under Mr. Ball's tutelage. And we look forward to hearing from you.
Appreciate it. Thank you.
Welcome.
Thank you.
With that, if you would like to call the first case.
Yes, Your Honor. Charles Thomas Johnson versus State of Tennessee.
This is Mr. Clace's first argument and likely my last, so. My name is Michael Mize, and I'm from the Dickson County Bar. I represent the appellant, and yes, I would like to reserve 5 minutes for rebuttal.
All right.
However, I don't think that will be much of a problem because this will be a fairly short argument as well. I came to this fairly late. In fact, I just saw Sean Anderson as he was leaving there. I came to law pretty late in my life. I was 47 at the time that I entered the National School of Law, and when I graduated in 2007 and 2008, Judge Woodall and I attended church together, and he asked me if I would take appointments. I was still teaching full-time at that time, and I said, sure. So the very first appointment that I received was a post-conviction appeal. And to be honest with this court, I had no idea what post-conviction was. I didn't know what a post-conviction hearing was, or relief, or petition. So I spent a lot of time in that very first one learning that. And I was just telling counsel when I came in my very first time to argue here, there was an attorney who was asking me what was the nature of my case, and when I explained it to him, he gave me his condolences. But I do want to say this, in this particular case, as in many post-conviction appeals that I have now argued in the past, by the way, I've never done a post-conviction hearing. I've never actually represented a defendant in that particular case, but I have come to find that at least in the cases that I've had, that there is almost always a deficiency in the evidence that is presented at a post-conviction. I'm not sure exactly what the reason is for that. As this court well knows, there is no real remedy for deficient counsel in post-conviction hearings. That may be part of it, I don't know. But getting to this particular case, the trial court in its order expressed several times that it really couldn't make a proper judgment given the little evidence that was presented. And we see this throughout the case. However, what I hope to do today, and the reason I'm before you in oral argument, is to hopefully encourage this court not to have that prevent them from making a judicial and just decision. For example, and there are two, as you can see in the brief, there are two specific issues that I would like to address and that I did address in the brief. To be honest with this court, when I first began studying the record and preparing for this particular appeal, I struggled. I struggled at first In fact, I was very close to filing an Anders brief because I wasn't really sure how we could argue this. But then I did light upon, I believe, these two very important issues. So one of them involves the GPS tracking system in this case, and the other one involves the confession that was made by the defendant not only at the scene that evening at the stop, but also the next morning at the jail. And the court again expressed, the trial court, that the court received no tracking order as to the GPS, who requested the GPS, and little evidence on the legitimacy of that GPS. And even though the court expressed, and it is true that a pretextual stop is not prohibited if it is a legitimate traffic stop, I would argue that counsel at the trial should have pursued the issue of the GPS much stronger because
How was it pursued at the PC hearing, though? What proof was offered to show that it would have been suppressed at the PC hearing? Because, as you well know, you said you've done numerous PCs. The law basically is you have to put on the motion to suppress at the PC hearing to show the prejudice. I agree with you on the deficiency argument, but how are you showing the prejudice? What proof is there at the PC hearing?
That's correct, Your Honor, and the only proof is actually the testimony of the defendant. At this hearing, as is the case at many hearings, the only testimony was by the defendant himself and then by the trial counsel. There should have been. I agree, and there wasn't.
So how do we get to prejudice if there's nothing there?
I think it could be possible to get to it in the fact that it's clear. It's almost like clear error in the sense that whether or not, in other words, a remedy could be whether or not there was a suppression in evidence at the PC hearing, this court could determine that that issue, the GPS, was so important that it remanded it back to have a new hearing in that particular case. I don't know if there's any precedence for that.
Well, let's talk about the deficiency, if we could, here for just a moment. Is there any proof that there was not a warrant for the GPS device?
There is not.
Okay. Whose car was it?
There is some debate about that. If you look in the record, the vehicle actually belonged to the brother of the defendant.
Okay, so not the defendant's car.
Correct.
How does he have standing to challenge it? I think I'm pushing back gently on the fact that we're assuming there was deficient performance. If there's no proof that there wasn't a warrant and the defendant may not have had standing to challenge it, where is proof of the deficiency?
That's a great question, Your Honor.
Fair enough.
And I would argue that getting back to deficient counsel, that had there been a suppression hearing based upon the GPS, there was a suppression hearing as to the confession. We'll get to that in a minute. But as to the GPS, there was not. Had there been, maybe that could have been addressed at that hearing. There was none.
Okay, fair enough.
And in fact, getting back to deficient counsel, it is in the order, well, excuse me, it's in the transcript of the PC hearing that the counsel testified, the trial counsel testified that he looked into it. But we don't know what that means. I have no idea what looking into it is, and our argument would be that he should have pursued it. It was such an important issue that there should have been a suppression hearing, and it should have been addressed, because obviously.
So, but the PC it's the petitioner's burden to establish he's entitled to relief. And so your statement there just kind of caught me. We don't know what he means by he looked into it. Well, then isn't it the petitioner's burden to ask those questions at the PC hearing so we can know what he means by I looked into it? I mean, so the fact that we have a vague answer is not on the state or even on the trial judge. It's on the petitioner for not asking the question, correct?
You're right, Your Honor, except for I'd argue that the petitioner, the defendant himself, doesn't have any experience in understanding that's what should have been done, and the petitioner's counsel should have, but there's no remedy for.
I say the petitioner, I mean his counsel should have followed that up.
Yes, yes.
But if the petitioner has no evidence that the car was his and has no expectation of privacy in the car, what would trial counsel have looked into?
That's a great question, Your Honor.
I mean, so even if trial counsel, and he didn't testify as to this, but even if he testified at the post-conviction hearing that I didn't consider it at all, I mean, without the petitioner coming forward with some evidence that he had an expectation of privacy in the car so as to have standing to challenge a Fourth Amendment issue, is there any deficiency in this record?
I agree, Your Honor, and once again, had there been a suppression hearing, had that been addressed, had the trial counsel further pursued that whole issue, then I could better answer your question. And
Sure, but even at the post-conviction hearing, the petitioner didn't come forward with evidence in his own testimony showing that he had a privacy interest in the vehicle.
that's correct.
Okay.
So just as, for example, of course, the state rightfully argued, just as you are bringing out this point, that there was no suppression evidence at the PC hearing, I argue once again that that's kind of a double deficiency of counsel, and that has been a problem with many PC hearings. And after all, the only reason I tried to drive the point home is that if there were no stop, or if the stop is illegal, then the whole case really depends upon that. The second issue really deals with this confession tape. If you recall, in looking at the case, one of the issues on appeal, on direct appeal in this particular case, involved the fact that that law enforcement lost all tapes, all recordings, body cams and recordings and all that type of stuff was lost, and the only actual tape they have is the confession that the defendant made the next morning after being jailed. There is testimony by one of the officers that the primary reason for the arrest was the confession that the defendant made at the scene. But he also, the officer testified that he was sweating, he was shaky, there seems to be testimony he was obviously extremely sick, and whether that confession itself could be taken as a legitimate confession is something that may have been addressed if there were an actual tape. Well, I'm using more time than I thought. Okay. As an actual tape. But in this particular case, because there was a whole, on the direct appeal was the whole Ferguson address, and he did not prevail on that. And that's why I argue that the confession tape, which, by the way, at trial was referred to. So the jury did hear testimony that he confessed. However, they didn't hear the confession tape. And since the confession tape was not suppressed, my argument is the confession tape may have shown the jury that he was dope sick at the time. He was even sick the next day. If you listen to the confession, you hear that the officers are even concerned with the fact that he's about to throw up and he's sick. And they do ask him if he needs a doctor, and he refuses that. But my argument would be that maybe the jury, if they had heard that tape, would see that he was sick at that particular time, and even though it was not suppressed by the court, the jury themselves could have taken notice of that. The loss of all the recordings also makes an expert that could have testified as to how he was coming off of heroin and how being dope sick would have an influence on that. And since the tape was not suppressed, why wasn't it used?
Well, I don't know if it was the trial court and its findings or counsel or maybe both, but how do you respond to the fact that I read in there somewhere that, well, counsel didn't want to produce the tape because he didn't want to highlight the confession. I mean, that's a strategic decision on behalf of counsel, correct?
I understand that, Your
Maybe a
Honor.
poor one in your opinion, but it's still a strategic decision.
It is a strategic decision. However, I would argue that the tape, the confession, was mentioned in the transcript at the trial several times, and by not introducing the tape, it didn't even, at that point, it was, I would think, in the jury's mind, an assumption that the confession is good. And I still argue that he should have at least given the jury an opportunity to see that he was sick during the confession. But
So with respect to your expert claim, though, I mean, Black versus State would require the petitioner to place that expert in evidence at the post-conviction hearing. Was an expert identified or presented at the post-conviction hearing?
no, Your Honor.
I mean, as you stated, I mean, the detective at trial described the petitioner's condition. So the jury had before it evidence of the petitioner's condition at the time it was considering the confession. How is it that having the tape in addition to that would have changed the outcome of the trial? Or having the recording would have changed the outcome of the trial? I mean, the jury already had the information, so what would the recording have added to it?
Well, Your Honor, I believe the jury did have the information of the testimony. However, to hear it, and I would argue that that testimony wasn't enough to really reveal to the jury how serious the dope sickness was.
Okay, is there any evidence in the post-conviction record that he was actually suffering from heroin withdrawal outside of his own testimony?
No, except for the comments that were made during the confession by the detectives that were doing the interview and by his comment.
Okay, so at least we would have to infer something from the detective's statements, but is there any evidence that he actually was in heroin withdrawal at the time that he was making the statement?
There is not.
Okay, all right.
I wish I could say there was, but there is not in the record. So finally, the primary argument here, of course, are the two that I have in the brief, but also in hopes that the court could take into consideration that there was deficient counsel at the PC hearing as well. Any other questions?
Thank you.
Your Honor.
May it please the court, Christian Clace, again, on behalf of the state. It's the state's position that neither of the petitioner's claims entitle him to post-conviction relief, and unless this court would like to begin elsewhere, I'll take up the GPS issue first, and just proceed in order of the petitioner's counsel's arguments. So in this particular case, it's the state's position that the trial counsel was not deficient with regard to his decision not to argue to suppress the evidence based on law enforcement's use of a GPS. Just as a brief background, trial counsel did file a motion to suppress in this case. He argued that law enforcement unconstitutionally prolonged the stop and tried to suppress the evidence based on those grounds. So trial counsel did try to suppress the evidence from the stop. He also argued in the motion to suppress that the confession from the petitioner should have been suppressed as well. The trial court denied those, but trial counsel was not deficient. He tried to suppress the evidence from the stop. As this court touched on with some of its questions, there really is not any evidence in this particular case that the GPS was warrantless. There is no basis in the record for the or for trial counsel, to have argued that the warrant or the GPS was illegal. So
What evidence is there that trial counsel even looked into the GPS issue, though?
aside from his statement that he looked into it, there is nothing explicit in the record, Your Honor.
Is there any evidence that he sought to suppress the stop itself by arguing either that the touching of the fog line was outside of State versus Smith, or to say that the stop itself was otherwise improper, save, I mean, just even absent the GPS?
I don't believe so, Your Honor. I believe it was solely the issue of prolonging the stop itself. I don't believe that he actually challenged the stop itself.
Why not? Was that asked?
I don't believe so, Your Honor. I don't think that came up at the post-conviction hearing. Aside from those points on deficiency, the state would also submit that the petitioner simply has not proven prejudice here. There was no evidence introduced at the post-conviction hearing to establish that a motion to suppress would have been granted in the trial court, or anything to establish that the Fourth Amendment claim really has any merit at all insofar as it concerns the GPS. This is...
Would you concede that if there were a basis to suppress the stop, would you concede that the prosecution could not have gone forward?
If there were a basis to suppress the stop?
In other words, is this question purely one of deficiency?
I think so, Your Honor.
Okay.
I believe that absent the stop, the state probably would not have had evidence.
Okay, so had the stop been suppressed, if there were a basis to do that, then the outcome of the proceeding certainly would have been different.
I believe that's correct, but the petitioner certainly has not proven that in the post-conviction hearing.
By way of a deficiency?
Correct.
Okay.
So unless this court has any further questions on the GPS point, I'll turn to the issue of the petitioner's jailhouse confession. Again, the state would argue here that trial counsel was neither deficient nor that any deficiency caused prejudice here. As this court alluded to, this was a strategic decision by trial counsel. The post-conviction court characterized this confession as damning, to quote the court, and it's completely reasonable that trial counsel would not want the jury to see this confession, particularly given that trial counsel indicated his strategy was to focus on the possession aspect of the drugs at trial. So any evidence coming in from trial counsel suggesting that the petitioner possessed the drugs would undermine that strategy, and it would not be something that trial counsel would want to do, and it's objectively reasonable.
So your friend on the other side, though,
Yes.
says that the confession was already before the jury. Is that true?
Yes,
In
it
fact,
came.
the detective testified about the confession.
That's correct.
Okay. State versus Walton says that a confession itself is among the most probative of all evidence in a criminal case. Are you saying that the reasonable strategy here was to ignore the confession that was already into evidence, not argue that the confession itself was the product of a heroin withdrawal, not try to explain why the confession itself may not be a voluntary statement? That's a reasonable strategic decision?
I'm not sure that I would characterize it as ignoring the confession. The confession, the tape was not played at trial, so it came in through the testimony of law enforcement, and the state also relied heavily on the testimony of, I believe it was the petitioner's girlfriend, is who was with him in the car. So my understanding of the record is that these individuals were cross-examined at trial, and ultimately trial counsel strategy was not necessarily to ignore the confession, but require the jury, by accrediting the testimony of these witnesses, to rule against the petitioner. But I would not say that he ignored the confession. Turning to prejudice, the petitioner never presented any expert testimony at the post-conviction hearing. There was no suggestion as to what this expert would have testified to, so there was really nothing for the post-conviction court to go on. And finally, it's unclear to the state how playing the petitioner's confession, given how probative these can be, playing this for the jury would have resulted in the jury going the other direction in this case. And the petitioner certainly did not put on proof at the
Was the video of the confession introduced at the PC hearing?
I don't believe so, Your Honor.
Was it made part of the record as part of the trial record? The trial record being an exhibit to the PC hearing?
Respectfully, I'm not sure, Your Honor.
Okay.
So I thought that the video, I'm sorry, Judge.
I was just going to ask, are you aware of the substance of the confession?
My understanding of the confession is that the petitioner indicated he purchased drugs in Atlanta, and then at another point he stated to law enforcement that he had possessed them immediately prior to the stop, and then once he was aware that law enforcement was going to stop them. He gave the drugs to his girlfriend to try and hide from law enforcement.
In the videotaped confession from the next morning, did he indicate what he intended to do with those drugs before he'd been pulled over?
I would have to defer to the record. I don't remember explicitly what he said.
Because at the scene, I believe the officers testified that the heroin was for resale and the cocaine was he intended to give that to someone else. I was just curious if he had reiterated that in his more formal statement at the station.
I don't recall explicitly what he said. I apologize.
Okay.
I believe that's all I have. I would defer to my brief for any other issues, and I ask that you affirm the judgment of the post-conviction court.
Thank you.
Thank you.
Thank you. Your rebuttal, counsel?
The confession, by the way, is, I believe, only audio and not video. And yes, he does reiterate the differences between the heroin and the cocaine.
Consistently with what the officers conveyed that he had said.
I
on
believe
the
that's
scene.
true, Your Honor. It's been a minute since I've listened to the confession itself.
So if the confession's only audio, how is the jury supposed to pick up on the fact that the defendant is dope sick? As opposed to just,
Because
sounding differently. How are they supposed to pick up on that if they can't
Yes.
see how he's acting?
Because of the statements of the detectives themselves and the fact that they continue to ask him if he needs to, they're going to get a trash can, if he needs to throw up, and also if he needs a doctor.
Were those questions asked on cross-examination that the state just alluded to, that these individuals were cross-examined about the confession? Were they asked those questions?
I don't remember, Your Honor. I'm sorry. It's been a while since I haven't had an opportunity to revisit the transcript. So I don't know the answer to that question. I believe, I now devote my life primarily to the juvenile court system and in my practice. I was 8 years on the bench in the Dixon County Juvenile Court, and then now I devote myself to the other side of the bench in the juvenile court. That's kind of become my passion, and so I am trying at this point actually to clear my criminal defense for the most part, and certainly this. And one of my problems in my life is that I want to do too many things, and I can't. But one of the things that I do believe is important, which gets back to this point, and not necessarily this case, but I do believe that there should be, and I may address this with the Tennessee Bar Association, and there needs to be several good CLEs that really focus on how to represent a client in a petition for post-conviction relief. Because as all your honors have alluded to, yes, there are many deficiencies in the representation, and there's not a good remedy for that. So I would just basically argue that as Judge Greenholtz has argued, which I've never been in front of Judge Greenholtz, I do believe, yes, the GPS particularly is vital and would have been the whole case, and not addressing it, even at a suppression hearing or whatever, is certainly deficient.
Can I clarify just one point, if I could, please? So at the very end of your principal argument, you made the statement as you were getting ready to sit down that you thought that there was a deficiency in post-conviction counsel's representation. Obviously, there's not a constitutional right to effective assistance of counsel in a post-conviction proceeding. There are cases that recognize Rule 28 basis. That's not raised anywhere in this case. Is that correct?
That's correct.
Okay, all right.
Any other questions, Your Honor?
Thank you, counsel.
I'm going to head to the Hickman County Juvenile Court.
All right. Call the next case, please.
State of Tennessee versus Philip Jerome Gardner III and Latonia Maria Gardner.